What if I told you that starting 2026, thousands of green card holders could lose their status without committing a single crime, just because they didn't pass a new 3-year government review? If you think your green card is permanent, you might already be on a countdown you don't even know about. Welcome back to US Move and Money, where we cut through the noise and bring you the immigration information that matters most to your life and your family's future. I'm here today to walk you through something that every single green card holder in America needs to understand right now. What I'm about to share with you is detailed, it's significant, and it's going to require your full attention because this affects millions of lawful permanent residents across the United States. If you've been a green card holder for 5 years, 10 years, or even 20 years, and you thought your permanent resident status was exactly that, permanent, I need you to stay with me through this entire video because the landscape is changing in ways that most people haven't fully grasped yet. We're talking about a complete transformation in what it means to hold a green card in America. This isn't just another policy tweak or a minor adjustment to existing regulations. This is a fundamental reimagining of the relationship between the United States government and its lawful permanent residents. The law we're discussing today is called the Secure Paths and Integration Act of 2025, and it represents the most sweeping overhaul of immigration policy for green card holders in an entire generation. Congress has passed this legislation with the stated goal of modernizing our immigration system and promoting what they call deeper civic and economic integration of permanent residents into American society. But what does that actually mean for you, for your daily life, for your family, and for your long-term plans in this country? That's exactly what we're going to break down together today, step by step, requirement by requirement, so that by the end of this video, you'll know exactly what's coming and exactly how to prepare. Before we dive deep into the specifics, let me give you the single most important thing you need to understand about this new law. For decades, a green card has functioned as what immigration experts call a passive status. What that means is, once you obtained your lawful permanent resident status, as long as you didn't commit serious crimes, as long as you didn't abandon your residency by staying outside the United States for extended periods, and as long as you renewed your physical green card every 10 years, you were essentially set. Your status was secure. You could live your life, work your job, raise your family, and build your American dream without constantly looking over your shoulder or worrying about your immigration status. That era is coming to an end. The Secure Paths and Integration Act of 2025 is shifting the green card from a passive status to what can only be described as an active status. This means that maintaining your lawful permanent resident status will no longer be a matter of simply avoiding major problems. Instead, it will require ongoing proactive engagement with a new system of requirements, documentation, and periodic reviews. Your green card is no longer just a destination that you reached after years of waiting and processing. Under this new framework, it becomes more like a journey with mandatory checkpoints along the way. Checkpoints that you must successfully navigate every few years to maintain your status. Now, I can already sense some of you feeling anxious or worried as you hear this, and I want to address that directly before we go any further. Yes, this is a significant change. Yes, it will require preparation and effort on your part, but panic is not productive and panic is not necessary. What is necessary is understanding, preparation, and action. That's why we're here today. And that's why I'm going to walk you through every single aspect of this new law in clear, practical terms so you know exactly what to expect and exactly how to prepare for it. Let me start by explaining the stated purpose of this legislation, because understanding why Congress says they passed this law will help you understand the requirements they've created. The Secure Paths and Integration Act has two main objectives according to its supporters in Congress. The first objective is about modernization and efficiency. The government wants to digitize immigration records more comprehensively and create what they describe as a more streamlined, data-driven approach to immigration oversight. This is about bringing the immigration system into the 21st century with better technology, more accessible online portals, and more efficient processing systems. The second objective, and this is the one that directly affects your day-to-day life as a green card holder, is about integration. The argument that was made repeatedly in congressional debates is that this new framework will ensure that long-term permanent residents are more deeply connected to their local communities, more engaged in American civic life, and on a more stable and certain path toward potential citizenship if they choose to pursue it. The supporters of this law argue that it will help permanent residents feel more rooted in American society and will provide clearer expectations about what it means to be a contributing member of the community. Now, you might be thinking, that sounds reasonable in theory, but what does it actually require me to do? That's the critical question, and that's where we need to get into the specifics. The practical effect of this law is that it places a new and significant administrative burden on every single green card holder in the United States. It creates new responsibilities, new documentation requirements, and new checkpoints that simply didn't exist before. The centerpiece of this entire law is something called the Continuous Status Review, which you'll often hear abbreviated as CSR. This is the mechanism through which all of these new requirements will be enforced, and it's essential that you understand exactly how it works. The Continuous Status Review is a mandatory check-in process that every lawful permanent resident will be required to complete on a regular, ongoing basis. And when I say regular, I mean every 3 years. That's right. Every single 3 years, you will need to go through this review process. Now, this is completely separate from the existing 10-year green card renewal process. Your physical green card will still need to be renewed every 10 years as it always has been. The CSR is something entirely new, an additional requirement layered on top of the existing system. Think of it as a periodic re-verification of your eligibility to maintain permanent resident status. It's not just checking that your card is still valid, it's checking that you as a person are still meeting an expanded set of criteria for what the government now considers to be an active, engaged, and integrated permanent resident. The CSR will be primarily an online process, which is part of that modernization goal I mentioned earlier. You'll access it through government portals and digital systems. But don't let the word online fool you into thinking this will be quick and easy. This is not just logging in and clicking a few boxes. The CSR requires the submission of substantial new documentation that was never required before on such a frequent and regular basis. You will need to gather evidence, obtain verification from third parties, and compile a comprehensive package of materials that demonstrates you are meeting these new standards. So, what exactly are these new standards? What documentation are we talking about? The CSR focuses on two core areas that every green card holder will need to address. The first is something the law calls the civic integration requirement. The second is a more stringent and more frequent verification of your financial self-sufficiency and your continuous residency in the United States. Let's break down each of these requirements in detail so you understand exactly what will be expected of you. The civic integration requirement is one of the most novel and frankly one of the most debated aspects of this entire law. It's something that has never existed before in the American immigration system for permanent residents. What it means in practice is that during each 3-year review period, you must demonstrate that you have been actively participating in American civic life. This isn't about just living here and working here. It's about showing that you are engaged in your community in specific, measurable ways. The law provides you with 2 options for how to satisfy this civic integration requirement, and you get to choose which path works better for your personal situation. The first option is community service. Specifically, you must complete and provide verification for 40 hours of community service during each 3-year period. This service must be performed at a registered nonprofit organization, a public school, or a government-recognized community entity. When you break it down, 40 hours over 3 years works out to an average of just over 13 hours per year, or about 1 hour per month. The government's reasoning is that this is a manageable commitment that encourages permanent residents to give back to their communities and build deeper connections where they live. The second option is to complete a new government-certified American Civics and Governance course. This will not be the simple civics test that people take when they naturalize. This will be a more comprehensive educational program covering the United States Constitution, the structure of American government at the federal, state, and local levels, and the rights and responsibilities of both citizens and permanent residents. These courses will be offered online and at various educational institutions around the country. Upon successful completion, you receive an official certificate that you then submit as part of your continuous status review application. Now, what's the government's stated rationale for requiring either community service or a civics course? According to supporters of this law, the goal is to move beyond what they see as the outdated concept of permanent residency being just about physical presence in the country. They want to foster what they call a sense of belonging and shared responsibility among long-term residents. The idea is that by getting involved in local communities through volunteer work or by gaining a deeper understanding of American government and civic institutions through education, permanent residents will feel more connected to the country, will be better prepared for citizenship if they choose to pursue it, and will be more engaged members of their communities in the meantime. On the surface, that might sound like a reasonable goal. After all, who could argue against community involvement and civic education? But we need to be realistic about the practical challenges and potential pitfalls of implementing this requirement across millions of diverse individuals with vastly different life circumstances. Think about a single parent who's working 2 jobs just to make ends meet and provide for their children. For that person, finding 40 hours to volunteer, even spread out over 3 years, could be incredibly difficult, perhaps even impossible, without making serious sacrifices to their family's financial stability. Think about elderly permanent residents who may have mobility limitations or health issues. Think about individuals with disabilities who may face physical or cognitive barriers to traditional volunteer work or classroom learning. The law does include provisions for waivers in cases of hardship, disability, or other special circumstances. But the details of how those waivers will work, what documentation will be required to obtain them, and how difficult the waiver process will be, all of that remains to be seen as the regulations are written and implemented. There are also significant administrative questions that still need to be answered. Who decides which nonprofit organizations are qualified to verify community service hours? What systems will be put in place to prevent fraud or misrepresentation? Will the civics course be offered in multiple languages for permanent residents who are still working on their English proficiency? Will there be fees associated with the course, or will it be provided free of charge? These are not small details. These are questions that will determine whether this requirement functions as intended or becomes an overwhelming burden that traps well-meaning people in an impossible situation. It's a well-intentioned concept in theory, but the implementation will be absolutely critical, and that's why it's so important that everyone in the immigrant community stays informed as these regulations are developed and makes their voice heard if they see problems emerging. Now, let's move to the second major component of the continuous status review, which focuses on financial self-sufficiency and continuous residency. On the surface, these might sound familiar because they've always been part of immigration law in some form. The concept of being financially self-sufficient and not becoming a public charge has existed in American immigration law for a very long time. What's different now is the level of scrutiny and the frequency with which you'll need to prove it. Currently, your financial self-sufficiency is primarily examined when you first apply for a green card. It might come up again if you're re-entering the country after an extended absence or if you're applying for citizenship. But once you have your green card and you're living in the United States, there isn't a regular scheduled check-in where you have to prove that you're still financially stable. Under the new law, that changes dramatically. As part of your continuous status review, every 3 years, you will need to submit evidence of your continued financial stability. What kind of evidence are we talking about? The regulations are still being finalized, but based on the language of the law itself, you should expect to provide your tax returns for the preceding 3 years. This makes sense because tax returns are an official government document that shows your income, your employment status, and your overall financial picture. In addition, you will likely need to make a declaration that you have not received certain federal means-tested public benefits during the review period. The specific list of which benefits will count against you in this review is still being determined, but this is expected to be one of the most contentious parts of the implementing regulations. This is where things get tricky and where you need to pay very close attention as more details emerge. There are many different types of government assistance programs in the United States. Some are universal programs that anyone can access regardless of income, like public education or emergency medical services. Some are insurance-based programs where people pay into the system and then draw benefits like Social Security, retirement, or Medicare. And some are means programs specifically designed to help people with low incomes like food assistance or housing subsidies. The government has indicated that receiving means tested benefits could potentially affect your continuous status review, but the devil is in the details. Will there be a distinction between short-term emergency assistance and long-term dependence? Will receiving food assistance for a few months during a period of unemployment be viewed the same way as receiving housing subsidies for years? Will benefits received by your children affect your status even if you yourself haven't received anything? These are life or death questions for families who may face temporary hardships, and the answers will have enormous consequences. The continuous residency component is the other half of this requirement. The fundamental rule has always been that a green card can be considered abandoned if you spend too much time outside the United States. Generally, if you're outside the country for a continuous period of 1 year or more, or sometimes even less, if you demonstrate an intent to live elsewhere permanently, your green card can be revoked. That basic rule isn't changing. What is changing is that the CSR creates a more frequent and more formal checkpoint to review your residency patterns. As part of each 3-year review, you will likely need to provide evidence of your ongoing ties to the United States. This could include proof of employment or self-employment in the U.S., documentation of property ownership, or a long-term lease showing you maintain a home here, records of U.S. bank accounts where you conduct your financial life, and information about family members who reside in the United States with you. The purpose of collecting all this evidence is to proactively identify individuals who may be living and working primarily in another country while trying to maintain their U.S. green card as a backup option. It's designed to make it much more difficult to be what immigration lawyers sometimes call a commuter permanent resident, someone who spends most of their time abroad but periodically returns to the U.S. to maintain the appearance of residency. This probationary status represents an entirely new layer of legal jeopardy for green card holders. It's something that has never existed before. In the past, if you maintained your green card and avoided serious crimes, your status was secure. Now, there will be this ongoing possibility that administrative failures, documentation problems, or life circumstances could put you into this precarious probationary status where you're one step away from losing everything you've built in America. Given everything I've just explained, I know many of you are wondering what you should actually be doing right now to prepare for this new reality. Let me give you the most important practical advice I can offer, broken down into clear action steps that every green card holder should start taking immediately. First and most importantly, do not panic. I cannot stress this enough. This law is new. The specific implementing regulations that will determine exactly how all of this works are still being written by government agencies. There will be a rollout period. There will be time to prepare. The sky is not falling tomorrow. Panic leads to bad decisions, to wasting money on scams, to making unnecessary changes to your life out of fear. Stay calm, stay informed, and take measured, thoughtful steps to prepare. Second, start documenting everything right now. This is hands down the most practical and valuable advice I can give you. Do not wait until your review period comes up in 2 or 3 years. Start building your documentation file today. If you volunteer at your child's school, at your place of worship, at a local food bank, or at any community organization, get a letter from them documenting your hours. Ask for it now while the memory is fresh and while your service is ongoing. Keep meticulous records of everything related to your employment. Save copies of pay-ubs, W-2 forms, employment contracts, and any other proof that you are working and earning income in the United States. Keep all of your tax returns and tax documents in an organized file that you can easily access when needed. Create what I call a residency evidence file, where you keep copies of your lease agreements or mortgage documents, utility bills showing your U.S. address, bank statements from U.S. financial institutions, car registration and insurance documents, and anything else that demonstrates you maintain your life and your home in the United States. If you travel internationally for work or family reasons, keep detailed records of your travel dates. the purpose of each trip, and documentation showing you always return to the US. When the time comes for your review, you want to have a well-organized, comprehensive package of evidence ready to go rather than scrambling at the last minute to recreate 3 years of your life. Third, understand the timeline and stay informed through reliable sources. The Secure Paths and Integration Act of 2025 is scheduled to take effect on January 1st, 2026. The first group of continuous status reviews will begin later that year, likely rolled out in phases based on when individuals first received their green cards. The government will announce the specific details of this phased rollout well in advance. Your job is to pay attention to official sources of information. That means checking the U.S. Citizenship and Immigration Services website regularly. That means signing up for email updates if USCIS offers them. That means watching a reliable immigration news sources and YouTube channels like ours that are committed to giving you accurate, verified information. What you should not do is rely on rumors, on Facebook posts from people who don't cite their sources, on WhatsApp messages that get forwarded around with no verification, or on social media speculation. In times of change, misinformation spreads rapidly, and acting on false information can be worse than not acting at all. And fourth, for any complex personal situation, consult with a qualified immigration attorney. Everything I've shared with you today is for educational purposes. It's designed to give you a comprehensive understanding of this new law and what it means for green card holders generally. But I am not an attorney, and this is not legal advice for your specific situation. If you have unique circumstances, if you have past immigration issues, if you've received public benefits and you're worried about how that will affect you, if you have health problems or disabilities that make the civic integration requirement difficult, if you travel frequently for work and you're concerned about the residency requirement, then you need to sit down with a qualified immigration lawyer who can review your individual case and give you advice tailored to your specific needs. A good immigration attorney can help you understand exactly how this law applies to your situation, can help you start gathering the right documentation now, can assist you with waiver applications if needed, and can represent you if you end up in probationary status or facing removal proceedings. Yes, attorneys cost money, but for something as important as your ability to remain in the United States and keep your green card, it's an investment worth making if your situation is complicated. This law fundamentally transforms what it means to be a lawful permanent resident of the United States. It changes the green card from a relatively stable, secure status that you could maintain almost indefinitely by simply avoiding major problems into an active status that requires ongoing engagement, regular documentation, and periodic proof that you continue to meet evolving standards. It's a significant shift, and it will require adaptation from millions of people who have built their lives in America. But here's what I want you to remember as we wrap up today's deep dive. You are a valued part of the fabric of this nation. You came to the United States legally, you've followed the rules, you've built a life here, you've contributed to your communities, and you belong here. This new law, whatever its motivations and whatever its ultimate effects, presents a new set of challenges for you and your family. But challenges can be met with preparation. Knowledge is your most powerful tool. Documentation is your evidence. Action taken today will pay dividends when your review period arrives. Approach this new era of immigration policy with diligence and with seriousness, but not with fear. Fear paralyzes us. Fear makes us make bad decisions. What you need instead is clear-eyed understanding of what's required, systematic preparation to meet those requirements, and the confidence that comes from being ready. By following these new rules, by keeping good records, by staying informed, and by seeking help when you need it, you will be able to navigate this system successfully. You will be able to prove again and again that you are exactly what you've always been, a contributing, integrated, committed resident of the United States of America. I want to thank you for trusting US Move and Money to bring you this critical information about the Secure Paths and Integration Act of 2025. I know this was a lot of information to take in, and I appreciate you staying with me through this detailed explanation. If you found this breakdown valuable, if it helped you understand what's coming and how to prepare for it, I would be incredibly grateful if you would take a moment to like this video. That simple action helps the YouTube algorithm show this information to more people who need it. Share this video with family members, friends, colleagues, and anyone else you know who has a green card and needs to understand these changes. And please, if you haven't already, subscribe to US Move and Money and turn on notifications so you never miss our coverage of immigration news and policy changes. We're committed to being your reliable source for accurate, detailed, practical immigration information that you can use in your life. In our upcoming videos, we'll be following up on this topic with more specific guidance. We'll do a step-by-step walkthrough of the continuous status review process once the official forms and procedures are released. We'll cover strategies for documenting your civic integration and residency. And we'll also be creating content about the ultimate goal that many permanent residents are working toward: United States citizenship through naturalization. In fact, our next major video series will walk you through the entire naturalization process from start to finish, covering the application forms, the documentation requirements, the biometrics appointment, the naturalization interview, the civics test, and finally the oath ceremony where you become a United States citizen. If you're a green card holder who's thinking about taking that next step, you absolutely won't want to miss that series. I want to hear from you in the comments section below. What's your reaction to this new law? How do you think the civic integration requirement will affect your life or the lives of people you know? Do you see these changes as a reasonable way to promote integration and community engagement, or do you view them as an unnecessary burden on legal residents who are already contributing members of society? What aspects of this new system concern you the most? What questions do you still have that I can address in future videos? Let's have a respectful, thoughtful conversation in the comments. Your perspectives and your questions help shape our future content and help me understand what information is most valuable to you. Until our next video, stay informed, stay prepared, and remember that knowledge and preparation are your best tools for navigating the changing landscape of American immigration law. This is US Move and Money, and I'll see you in the next.